protest establishment-approved subject matter such as race and climate change or LGBTQ, you can go ahead and block roadways, toss paint around, block up buildings, invade the offices of the mayor, of Senator Warren, do all that stuff and more, even assault police officers, and your case is going to get dismissed. In fact, one of these individuals that we surveyed, one of my defendants, and there are plenty of repeat offenders within this category, touts these arrests that he's gotten off of on his website as means of monetizing and raising money.
Yes.
If, on the other hand, you're conducting a peaceful protest, just standing there, maybe carrying a sign, chanting, if you're protesting against Mayor Wu or vaccines, they're going to give you a full-throated prosecution. It's no surprise because this attorney has come out publicly and said that he finds these protests against Mayor Wu hateful and violent and that they have no place in a civilized society. That's what we're living under right now. And it should be objectionable to every American citizen.
What? All rise, please. Court's in session. You may be seated. All cell phones are to be turned off and stowed away, please. Cell phones are not permitted in the courthouse. Thank you.
Good morning, everyone. Today is December 8th, 2023. This is the West Roxbury Division of the Boston Municipal Court, third session. The Honorable Judge Kathleen Coffey presiding. The Commonwealth versus Catherine Vitale, docket number 2206CR0590, and Shannon Llewellyn, docket number 2206CR0593.
Good morning. Would the parties identify themselves, please?
Good morning, Your Honor. 88 Maxwell, remedy for the Commonwealth.
Good morning, Your Honor. William Gens for the defendants.
Good morning. All right. How would you like to proceed? I'm aware of the fact that it was almost last evening, I think it was 2004, that a second supplemental memorandum was filed.
Yes.
Did the Commonwealth have an opportunity? Did you serve the Commonwealth?
Yes, we did. I'm not asking for action to be taken on that. That's part of the process of what I'm doing in installments. But let me ask a couple of questions. Did the copy that the court did have a binder clip?
Say that again, please.
Was it secured by a binder clip like this? Let me give you this one here because it's so much easier to work with, and I'll struggle with the loose one. The second thing is that when I prepared that, it was prior to receiving the court's order on the joinder. And I was planning on doing one for each client, so it just says Shannon Llewellyn on it, but so if we can just change the caption, the clerk can designate it as for both. Okay. Finally, with regard to that, there's a exhibit master list that can accompany it and make it useful for anyone who is looking at it to key into the exhibits, besides by number, also by page number.
Do you want to file that now?
Yes, and I've provided a copy to the Commonwealth.
Okay. You already did, and you're going to?
Yeah, I did.
Thank you.
And then there are two other submissions. As a result of the joiner ruling, I have a motion for a bill of particulars, a very, very narrow one, which asks for particularization of anything, any joint venture claimed in this matter. This is a particular concern to me, given the Commonwealth's recent submission on the selective prosecution discovery. It has a fact section And it says, and I quote, "The protesters were chanting and banging on a pot." Miss Vitale wasn't banging on a pot. It's on video. And I can only assume that this is being made under some kind of joint venture theory of the case. Highly inappropriate unless they could have, the Commonwealth is proceeding on a joint venture theory. And if so, I'd like it particularized.
Well, why don't you file it? You haven't filed it, so I don't really know what you're talking about.
Okay, I'll file it right now. I'm not gonna ask to do it right now. I'm just telling you why I'm filing it at this juncture.
All right, that's fine.
I have no objection to it. I think that's a fair request.
Okay. And again, you served the Commonwealth?
Indeed.
Yes, I do have it.
Okay, when? This morning?
Yes.
Okay, fine.
And then the last thing that I have, which I've served the Commonwealth, is the Commonwealth filed, we filed in response to the court's request, a memorandum on requests, our previous discovery requests numbers 2 and 3. The Commonwealth filed an opposition, and
I think it was just number 3. I think number 2,
it was number
it's
2.
available on mass courts, the information that you see.
Well, that's what the Commonwealth was saying, and I wrote
I think number 3, according to my notes, number 3 is the one that I invited both of you to submit.
okay.
Or, in the alternative, for you to modify number 3 so it's more direct and tailored. Number three, for the record, number 3, you are seeking all other communications apart from the emails referenced above to or from the Boston Police, Suffolk County District Attorney's Office, and any member of the Mayor Wu's administration regarding the treatment, arrest, or prosecution of political protesters. That's very broad.
Understood, and
Very broad.
I conceded that.
And it involves 3 different independent government agencies.
And so what I did was in our memorandum, which has been filed and served, it's called Defendant's Memorandum of Discovery Request, although it has a discussion of question number 2. It then what follows on request number 3 is a proposed revised request number 3.
And when are you going to file that? Or did you already file that?
It already has been filed, but I have another copy for you if
When was it filed, please?
that was went out in the mail either Monday or Tuesday.
Of this week?
Yeah. Well,
We didn't get it.
here it is.
It's the holiday season, so it didn't arrive at the court. But if you want to file it now, I certainly will accept it. And
If you
and
go,
again, you gave a copy to the Commonwealth this morning, please?
I didn't give one to the Commonwealth this morning because we had served it by mail already.
Did you
But
get it in the mail?
No.
So,
It's not included in this packet, correct?
no, it
so
isn't.
they didn't get it and we didn't get it. So if you have an extra copy, if you don't, I'm happy to have a copy made.
I think that we need to have a copy made because what I wanted to do was read the revised request and the Commonwealth could respond to it and you could respond to it as well because we cut it down.
Yeah, but in fairness to the Commonwealth, this should have been done. So they don't have it in front of them.
No, I understand that. And I hope we're remedying that in a moment.
Okay. All right, Attorney James, the court officer, made a copy, so.
so does the Commonwealth have one now?
No, it's right here. Now they're gonna get it.
Okay, thanks.
In any event, Your Honor, at the bottom of page 3 is where the revised request can be found. What we did was we cut the time period from January 22nd to the present, so that issue was addressed. And then it was narrowed a second request as instead of all communications regarding these things from all these entities, it just reads communications between these entities. The third respect in which we narrowed it, as a result of our discussion the last time, was that it would be contemplated the redaction of all work product material that the Commonwealth wants to designate as work product. I'm not interested in that. And it gave a description of what political protests would be the subject of the discovery request. So, time-wise, the scope of the communications, and the scope of the request not to include attorney work product. What I'm essentially looking for is more communications, if they exist, such as the ones that are already in our possession that we got from FOIAs. Master list, that sort of thing.
Would the Commonwealth like to respond? Do you want to review it? And I can give you another date to respond. Do you want to respond in writing? It's unfortunate that, again, that this wasn't filed earlier.
Yeah.
What would you like to do?
If I could briefly respond, I think crucially, I would ask the court to take no action because I don't have any sense of how onerous production would be from like a technological standpoint. I would need to talk to people in my office to ask how easily these types of email searches could be performed and how the data could be generated. If it's a very easy task, that's a very separate issue from if this is going to take multiple people working on it for a long period of time. If I could just be heard briefly, I think that there's kind of a fundamental issue with these discovery requests, and that being the kind of theoretical legal foundation. I think the Commonwealth's position is there's no viable selective prosecution theory or claim being proffered or contemplated here. What is actually being argued is something that ought to be argued at trial, which is that there was personal bias, perhaps motivated by political considerations, against these specific defendants by the law enforcement individuals involved. And certainly, so long as the rules of evidence are being abided by, that could theoretically be raised on cross-examination of police officer witnesses, in opening and closing arguments, but that's a very separate concept from a selective prosecution claim as a basis for a motion to dismiss. I think the theoretical foundations of the selective prosecution claim are flawed for various reasons. Principally, the fact that the defendants still have not articulated the purported impermissible classification. I understand that political affiliation has been raised and discussed, but it has yet to be stated in plain language what the political affiliation of the defendants, the relevant political affiliation was in this case that purportedly caused them to be selectively prosecuted. Additionally, and this is particularly relevant with respect to request number 2 of the discovery motion, there's a question of how political affiliation would be operationalized and measured with respect to other similarly situated individuals. Request number 2 doesn't ask for any data regarding political affiliation of the individuals referenced. So essentially the defendants are seeking outcome data, but not data on the purported explanatory causal variable. Again, if political affiliation is opinion regarding public policy position A, or if it's political party registration, that needs to be clearly identified and needs to be something that can be measured and data can be ascertained with respect to other individuals upon whom the Commonwealth will be ordered to produce data under discovery. That is, if defendants are proposing to proceed under a statistical analysis strategy with respect to raising a reasonable inference of impermissible discrimination.
Okay.
Your Honor, the Commonwealth is moving backwards here to the last hearing, and I'll address it. It should be quite clear. We made it clear in our papers, in our submissions, that the impermissible classification has to do with political affiliation and protest content. In other words, and we've shown this abundantly thus far, that if the political affiliation or protest content is against mayor rule and against vaccines and vaccine mandates, there is one type of treatment being dispensed by the district attorney's office, to some extent by the police. And if the protest content has to do with a whole potpourri of other causes, including alleged racism, climate change, LGBTQ issues, and the newest emerging category of pro-Palestinian protests, then there appears to be, thus far, in the survey with this latest submission, over 106 cases, complete leniency, dismissals every single time out.
But not straight dismissals. Not straight dismissals.
Not in every case, in some of the cases.
Dismissals, community service components.
I'll address that too.
Yes?
Out of the 106, there are 40 felonies cases. Those got community service, by and large. I would say to you that that hardly represents anything other than leniency. I was actually considering doing a survey in Suffolk County Corrections, not Suffolk County, National Street, and asking each and every defendant who was charged with a felony.
And what are the felonies that you referenced?
What are the felonies?
Yes.
They include assault and battery on police officers with serious bodily injury, breaking and entering with intent to commit a felony. I think there's a couple of arsons in there. The most recent one has the deployment.
All right, let me ask you this, please. Were they dismissed because the Commonwealth wasn't able to meet their evidentiary burden at trial?
No. They were dismissed largely either at arraignment or shortly thereafter. In virtually every instance.
And you're going to document that?
It has been documented.
No, are you going to identify with specificity the date, the time? I mean, you've submitted a considerable amount of exhibits.
They include
My question is, you're making a point, and it sounds like it has some strength and validity, but my question is, in making that point, in making that argument, are you going to support it with specific examples rather than just
Yes.
handing the court the night before 29 exhibits?
Yeah, it wasn't my intention to necessarily get into that material that's in that one there. But the very first one that we did, which was on the George Floyd riots, did have that degree of specificity. I intend ultimately to have a complete summary, essentially a spreadsheet that will show the level of the charges, the time it took to reach disposition, the disposition that was achieved, and then statistical summaries below it. I can represent to you at this point in time. And we have not curated these cases. We're taking them as they come. If I found dismissals or trials, I would report them. We're doing the best we can because we don't have access to the Commonwealth's records, so we have to do this in a backwards fashion. We have to reconstruct it through either news media reports or tips I get from police officers, etc. And running through the court system, it's a lot of work. Do it this way, but we're prepared to do it, and we have been doing it.
All right, let me give you all another date to allow the Commonwealth.
If I could very briefly, Your Honor.
It's not really necessary.
I would ask for your indulgence just because I think there's a very, very important thing that defense counsel just said.
Okay.
And that is that the purported impermissible classification is content of protest. That is not an equal protection claim. An equal protection claim relates to the characteristics of the individual, not the behavior or the conduct involved. It's race, religion, sex, gender identity, sexual orientation, or political belief or affiliation. It's something that exists within the individual, regardless of what behavior they then manifest. So fundamentally, it's not an equal protection.
All right, but we're going to discuss this at another time and date.
Sure.
So at this point,
I do
give
have,
me a date.
I do have other discovery matters to report on, if I could.
Okay.
Previously, on the last day, Your Honor had allowed request number 1 without objection. I was able to get in contact with an attorney from BPD Legal. They do not have the master list of protesters reference. They gave me the name of a sergeant at E5 who they recommended I reach out to. I called E5. He's not working today, but he should be back tomorrow or the day after. I sent him an email asking for the list, so I'm just waiting to hear back from that. I was also able to...
Do you agree that a list exists?
Certainly from the email that defense counsel provided in support of their motion, it seems that there is a list. I don't know whether it is still kept, what form it takes, but I'm happy to ask for it and turn it over to those within the Commonwealth's care custody.
I'm very much concerned about the loss, if not destruction of evidence in this matter. That email, which Judicial Watch obtained that email as part of a FOIA, that's how we got it. It's from a Boston police captain, I believe, to 25 recipients, and it states in part, quote, "We have a master list of protesters for identification purposes in the context of enforcement policy." For that to disappear,
All right,
would be
but
very troubling.
he's not saying that it has disappeared. So right now we're talking about speculation.
But
Once he reports to the court, I don't have it. Then you and I and the Commonwealth can discuss it.
Understood. I'm not making accusations. I'm just saying
I know.
my degree of concern.
I'm just trying to move this along.
Yeah.
No, I understand your concern. Okay.
I was also confirming with BPD Legal that there is no specialized unit within BPD that is designed to.
So may I suggest, Attorney Robidoux?
Yes.
You put this in writing.
Sure, absolutely. It's in those discovery.
Yeah. It needs to be in writing.
Absolutely.
In terms of your efforts and need help come up your efforts.
Now,
And then submit it before the next date, so council will have time in order to respond.
we're gonna submit it
to
in
the
hand this time instead of relying upon the US mails.
Okay, fair enough.
Can we still work with Fridays?
I'm sorry, sir?
Can we still work with Fridays as a?
That's fine, whatever convenient for the two of you. If Fridays work for you and if they work for the Commonwealth, I'll make sure it works for me.
I could suggest Friday, January 5th, is that okay?
Is that-
January 5, is that okay?
Yeah.
Okay, very well. Okay,
Okay, and,
so just so we're clear, what are we gonna do on January 5th?
well, we're gonna sort out this issue of that master list, whether that exists. The second is we're gonna address the, request number 3, or at least my proposal for a, the modification.
Okay, the discovery request.
I'll reach out to our IT department today to see again how onerous this would be.
Okay,
And
so so on January the 5th, just so we all have common understanding and we can get something done. The Commonwealth, by January 5th, will have put in writing exactly what, or they, better yet, they will hand over to you by January 5th, what has been ordered. And if the Commonwealth's position is that they're not capable or it's impossible to comply with the court's order, you need to document and outline your efforts and why you can't
Of course.
do that, okay? But everything needs to be in writing.
Yes, sir.
It's nice and clean. And then you'll have a chance.
sure,
And the bill of particulars as well, I'll provide
Yeah.
that by that date.
that might be on the court's list, that we'll deal with that, the bill of particulars at that time.
Fine.
And if the Commonwealth wants to continue this discussion on law, on selective prosecution, I welcome it. I've surveyed all the cases in the country, and there's lots of them, because this is a hot issue right now, as I'm sure the court has inferred already.
Thank you all.
Thank you.
For your patience and your courtesy. We'll see everybody back here January 5th. I hope everyone enjoys their holiday.
Have a wonderful holiday.
Thank you, Eric.
Thank you.
Captain Vitale, document number 2206 CI 0590, and Shannon Llewellyn, document number 2206 CI 0593. The release of the same terms and conditions here appears on January 5th, 2024 at 9 a.m. What?
Thank you, Mr.
Yeah.
A little premature.
Do you want compliance and election, or do you want another pretrial? I think another pretrial.
I think another pretrial.
Sure.
Okay, thank you.
Thank you, Eric. Thank you, Mr. Thank you.
Attorney Gens, I would love to have your comments on today's hearing, which was very short, with Catherine and Shannon's case.
Well, we're here at the West Roxbury Court on December 8th, and we have just recently filed our third installment of a collection of cases that we have gathered involving protest arrests. This one here is an additional 44 arrests. That's on top of the over 62 that we've already submitted. So we're up over 100 cases involving race matters, protests of climate change, protests of LGBTQ matters, and now increasingly protests of the Israel-Palestinian situation. These protests that we've gathered, most recent batch of 44 has felony arrests in it, all dismissed, has activities including blocking major bridges, roadways, invading public officials' offices, protesters chaining themselves to the entranceways of buildings, including Faneuil Hall. Highly disruptive activities. Each and every one of these cases, just like all the ones before, has resulted in dismissals. Unlike the full-throated prosecutions of protesters against Mayor Wu and against vaccines. And we're just continuing to build upon this show and to show that it is virtually monolithic and
That's okay.
wow. It's a courthouse. What do you expect?
Yeah.
And uniform across the board. The district attorney's office is attempting to claim that there is no such thing as selective prosecution based upon the content of speech, and we are relying upon established case law that says yes, there is, and upon the facts on the ground in the city of Boston, in the county of Suffolk, to show that that's what is occurring. If you want to protest establishment approved subject matter such as race and climate change or LGBTQ, you can go ahead and block roadways, toss paint around, block up buildings, invade the offices of the mayor, of Senator Warren, do all that stuff and more, even assault police officers, and your case is going to get dismissed. In fact, one of these individuals that we surveyed, one of my defendants, and there are plenty of repeat offenders within this category, touts these arrests that he's gotten off of on his website as means of monetizing and raising money.
Yes.
If, on the other hand, you're conducting a peaceful protest, just standing there, maybe carrying a sign, chanting, if you're protesting against Mayor Wu or vaccines, they're going to give you a full-throated prosecution. It's no surprise because this attorney has come out publicly and said that he finds these protests against Mayor Wu hateful and violent and that they have no place in a civilized society. That's what we're living under right now. And it should be objectionable to every American citizen.
Abramson of cruisemovies.com was here at North this morning in West Roxbury. And John's going to give a brief description of what he saw happen in the show.
Great. I took two notes on the video of the proceedings. This was a trial here. The case of Shannon, Llewellyn, Catherine Vitale, the couple of joined the cases together. And the judge was Kathleen Coffey. That's the name. Prosecutor, Commonwealth prosecutor, I don't know his name. The defense attorney is William Gantz. I'm going to be having a statement for them in a bit. And Bill has submitted, is going to submit a master list because he's alleging there's some selective prosecution related to other people who have committed even felonies and had their cases dismissed. Yet the Commonwealth seems to be going strong against Shannon and Catherine, who were protesting their leaders. Williams, house and mask and the vaccine mandates in Boston. The prosecution is trying to join the two cases together. And they're still talking about discovery and they're trying to work out the details of what's going to be in the case when it goes to trial. One case that Bill brought up was that it tries to join the two of them together and talks about banging on a pot. And Shannon was the only one banging on a pot, Bill pointed out. That wouldn't be reasonable to other cases. I guess claiming that there's some organized work of the two because they got people together. Yes. There's a number 3 request that the judge said she didn't really like because it involved looking for discovery.
struggle
Look at,
here trying to
well,
focus.
focus the left a little bit.
I know.
But anyway, I'm just trying to line up the cameras.
It's okay.
Anyways, there was an original number 3 request from the defense about getting property locations. Well, Boston Police Department, myself, and PA, and their rules office. And it was kind of broad, so they talked about Bill amending that to limit it to a certain date range, namely January 22, 23 to present, and that it was communications between these 3 entities versus all communications of the 3 entities. Because the judge doesn't like it involves such a broad bringing in of 3 agencies for discovery the communication. And Bill also is amending it to redact normal work product. The 2 things. The prosecutor opined, I thought it was interesting, that he was concerned about how onerous the discovery may become, and I think maybe that's the point. And he claims there's an issue with this request as far as its legal foundation. And he's trying to say that you can only claim selective prosecution because of who you are at the time of speech. And you found that really interesting. The judge said it should be done at trial. And I mean, the prosecutor said this should be talked about at trial. He didn't want to allow discovery on this. So it was very strange. And then there was a thing there, number 2, regarding a question regarding political affiliation, and looked like it was going to require some statistical analysis regarding discrimination with political affiliation. Then prosecutor is saying that the content of the protest is not a legal claim for discrimination. That's kind of what I already mentioned. The judge wants to know we're gonna have another date, that's the things, another pre-trial date. The prosecutor does admit that there, through previous discovery already, that there is reference to a list of targeted individuals, and but he kind of hinted that he didn't know if it was still around or destroyed or something. And Bill was showing his concern, not making any accusations, showing his concern about possible destruction. They set a date for January 5th, and to talk about the topics, its master list that people. And number 3, discovery requested its amendment, and so they would contact the ICE department right away, and that is my summary of what I heard.
Okay, thank you, John.
There's a very, very important thing that defense counsel just said.
Okay.
And that is that the purported impermissible classification is content of protest. That is not an equal protection claim. An equal protection claim relates to the characteristics of the individual, not the behavior or the conduct involved. It's race, religion, sex, gender identity, sexual orientation, or political belief or affiliation. It's something that exists within the individual, regardless of what behavior they then manifest. So fundamentally, it's not an equal protection.
All right, but we're going to